Good evening, everybody. If you would, please come in and have a seat, and we'll call the meeting to order. Okay. Chairman Anderson, you want to come up and explain substitute the Senate Bill 12?
Thank you, Mr. Chairman, and I will attempt to do what you have asked me to do. Senate Bill 12 is originally was a relatively short bill that simply defined custodian when it came to the question of open records requests, and this is still in the bill. Okay, it's section 2, I believe it is, of the bill now. So I'll talk about that first. But what the original bill did was to, actually it's section 3 now with the rewrite of it. But it defines custodian. It directs that all requests for public records shall be made upon a custodian. It also says that private persons or entities shall provide the custodian with those records upon request if they are indeed public records, and that they shall maintain those in accordance with statutory requirements as far as time frame and that sort of thing. And then we, in the sub, we've gone further and added the word public in many sections in front of the word record, simply because public record is defined, but just the simple word record is not in the code as amended. That is that portion of it. Now I'm going to drop back to section 1, and section 1 is relatively simple. It excludes, and I'm going to read this to make sure I get everyone. It says, when we're talking about agency, and this would be an agency subject to open records request, such terms shall not include the legislative branch, including but not limited to the General Assembly and its members, officers, staff, committees, commissions, and offices. We currently have and utilize legislative privilege on our conversations internally. What this does is this extends that to our conversations with other departments, primarily in the executive branch. That's my understanding as to the purpose of this. Then there's a lot of, and just my commentary here, there's a whole lot of pages in here where nothing is done. So the 2.5-page bill went to 34 pages, but the bulk of those pages there are no changes to. So I'm going to jump over to page 10, I believe it is. And this is under the reference to code section 50-18-72. This was a recommendation from the Prosecuting Attorney's Council. And what I'd like to do, if I may, Mr. Chairman, could I invoke the call a friend option and let Chairman Leverett explain this portion where there's just a couple of lines added to this code section.
Chairman Leverett.
Thank you, Mr. Chairman. And thank you, Chairman Anderson. I didn't think you needed any help. You're doing great. But so this is the statute 50-1872, which are the exceptions to the Open Records Act. And one of them are records of law enforcement relating to a pending investigation. But there's an exception to that exception. Even if there is a pending investigation, it's traditionally the word used in the code was the initial incident report, was still something that law enforcement would have to tender in response to an open records request. We're sort of clarifying that a little bit by making it the first incident report completed on a standard incident report form to clarify what is the exception to the exception. And then there's also a provision in that exception that says, well, it's at some point you can't use this exception about a pending investigation when the investigation is really pretty much over. And we're just finally, the language was, when all direct litigation involving the investigation and prosecution has become final or otherwise terminated. PAC has asked to clarify that because I think there's been some disagreement about what that means to, upon a final disposition of the accusation, indictment, or complaint and exhaustion of any right of appeal for all individuals charged on the same accusation, indictment, or complaint. So that was, I think, some just kind of I guess you could consider it cleanup or clarification that they requested to that particular provision in the exemption statute.
Okay, thank you, sir. Then we jump to page 26 in the current version, where there is added on line 677 and 678 a reference to the Department of Human Services, which I would expect was an omission in the original text of the statute that needed to be added to make sure we cover the appropriate departments within that section. Then the last provision that I have seen in the current rewrite of this occurs on page 30, where there are additional references to, as I mentioned earlier, the communications between the legislative branch and the executive branch. Mr. Chairman, I will
Okay.
be glad to attempt to
Got a couple of questions
answer
for
any
you.
questions.
Whip Park.
Thank you, Mr. Chairman. Chairman Anderson, you were right there on page 30 with respect to line 769 to 777. Why is the majority party trying to expand from disclosure or to keep private communications between the legislative branch and a private person or a private entity? Does that not greatly expand non-disclosure laws? What are y'all trying to protect? And what are you trying to hide, I should say? And then on line 774 to 777, again, we are excluding from public disclosure or keeping hidden from the public movements within a building, any sort of government building. Can you help me better explain why we are trying to hide more information from the public, especially when legislators are engaged in conversations or receive information from a private person or a private entity?
If you'll give me 1 second, sir, let me just make sure. Again, I was just given a fresh rewrite on some of this, so. Chairman Leverett, have you looked at this portion?
List.
Yeah, first of all, I appreciate the sense of loving kindness in which you asked the question. What are you trying to hide? I don't think we're trying to hide anything. There's currently existing under law legislative privilege and which protects conversations that we have with people about legislation. This is just saying just because it ends up a document or a communication ends up being in the hands of the executive branch doesn't remove the legislative privilege. It's still exempt from the Open Records Act.
My concern, I do have concern between further protecting conversations between the legislative and the executive branch, but again, this subsection 54, with respect to private persons or private entities and the performance of a service or function for the legislative branch.
Well, generally my understanding is if I have a private conversation with someone about legislation, legislative privilege applies to that.
So are you saying this simply codifies
Well,
existing
it
law?
does. It just makes, if you have a written record of the communication, it just exempts them from the Open Records Act, which just simply kind of furthers the existence of the privilege. Otherwise, the privilege doesn't really mean anything. And I would think there are times when we have conversations that involve, we rely on people to give us honest information, and if they think that we're going to have to say what they told us, they might not be as truthful with us about it or as forthright.
I would respectfully disagree. I think as elected officials, subject and held accountable to the people, I think the people should have the right, would you not agree, to know where certain information that impacts and influences legislation, where that comes from. Whether it is a extremist organization, whether it is a foreign billionaire, I think the people are subject to that information, in which my understanding and plain reading of this language is that would protect those sorts of conversations and communications.
I'm sorry for talking over you. I respect the opinion. I agree that's a different policy, but I think it's more important to get accurate information. And my understanding of the privilege is that's the policy that's been adopted by the application of the privilege, and that's why the privilege exists in the first place. And also, you had asked about electronic access system. My understanding is that has to do with the security systems here and the codes, and without that, people could get access to all of the codes and be able to access buildings without being tracked. So That's part of the reason for that exemption, although you didn't ask about that.
Well-
But you did make some references if we're
Yeah.
trying to hide our goings and comings. That's not what's going on.
Whip Burchett has a question.
Thank you, Chairman Anderson, for bringing the bill. Isn't it true, Chairman, that the federal government recognizes a much broader legislative privilege than the state of Georgia? And this language is in line with that legislative privilege that the federal government utilizes.
It is my understanding, sir, yes.
And isn't it also true that the key words in lines 770 and 771 are in the performance of a service or function of the legislative branch, and to the point of the Vice Chair, that when we are performing our legislative function, in other words, having conversations about legislation and deriving, putting together legislation, if we want those honest conversations, then folks don't want to be subject to any type of, request of the information. And this is just clearly an opportunity for us to maintain a good piece of, it's an opportunity for us to just align ourselves with a much broader legislative privilege. Isn't that true?
I would say yes, sir. And if I may further with that, just to speak on behalf of my colleagues who are not attorneys and seasoned in the ins and outs of law, it is difficult sometimes for us to determine what conversations we have in the course of conducting the business of the state and the legislature that are protected and are not. So what this does is for all of us, it provides a clarity, it provides a definitive answer to me of that question, that those conversations in the course of doing my legislative duties are protected.
Okay, we had a question, Representative Evans, I think.
Thank you, Mr. Chairman. To the chairman at the podium, the parts of the bill that were other than the 39 lines or so that you said were the original Senate Bill 12, has any of the language, including the language we've just been discussing at 767 to 777, and then the other new language that wasn't part of the original, was any of that in a bill that went through any substantive committee on either the House or the Senate side for any vetting?
I do not know the answer to that question.
How did it come to you?
It came to me as a rules committee sub that I am here presenting.
So as far as you know, this language, it may not have been ever vetted at all, other than what we're doing right here.
I can't speak to what may have been presented in the past. I'm not knowledgeable of any presentation of this session.
Well, if anybody on the committee knows, and it'd be up to the chairman if they could share now, but maybe they could share with me later. One other question, back on line 769. I understand the point that the whip and the vice chairman were making about our legislative privilege, and I don't disagree with that, but this language at line 769, wouldn't you agree, is way broader, because this says records or data relating to the legislative branch. I'm not really sure what that is. Also, it's going to protect just straight up data that an agency may create. An agency may create a spreadsheet summarizing information. It may summarize dollars relating to some budget item, and maybe that data was originally the request of someone from the legislature, but it's not. It's data. Just like the attorney-client privilege doesn't protect data, it protects communications and advice. This is going way further in protecting underlying data that perhaps we may request in a study committee that the public certainly has a right to know. Do you read it as broad as I do, and does that not concern you?
I will defer also again later to lines 170 and 171, where it does say that in the performance of a service or function of the legislative branch, or on behalf of the legislative branch.
Right.
Again,
Well, my
the
concern
data and the information, the records that would be covered in this would only be for the purpose of the performance of that function.
But wouldn't you agree that any data perhaps that the budget office prepares that summarizes dollars, reserves, spending over time, ups and downs, that's all probably requested from someone in this body, but the data is not part of our legislative thinking and crafting that I think the legislative privilege is designed to protect. Why are we trying to protect data and information in our state government from the public?
I would have to say you'll have your opinion on that. Again, my basis for supporting this would be in the performance of a service or function.
Do you agree that should be shielded from the public? If we ask the budget office to create summaries of reserves and ups and downs and projections, do you agree that the public shouldn't see that just because perhaps the budget chairman asked an office to create it?
I can't speak to every circumstance. I know there are circumstances when I do think that should be, yes.
Thank you.
Okay. Representative Miller has a question.
Thank you, Mr. Chairman. To the author of the bill, on line 237 through 238, where we do quote-unquote cleanup, oftentimes in investigations, criminal investigations, there are multiple incident reports and initial incident reports. Multiple officers, for example, can respond to the scene and give an incident report based on their observations. Is this meant to, and those are routinely produced because they are incident reports. When we say the first initial report for any officer or in any investigation, can you just tell me what we're trying to do with this?
I appreciate the question. I cannot answer that question. I would again defer to my learned colleague, Chairman Leverett, if I may, Mr. Chairman.
To answer the lady's question, as I read it, it's talking about the first incident report prepared. And my understanding is there's generally one incident report prepared for an investigation that's the initial one that's done. And that would be obtainable in open records. Now, this doesn't impact what you could get through discovery in the criminal case.
No. Thank you. I understand that. We're just talking about what is subject and available by way of open records. Is the intention to limit the amount of information that folks can get on a case through the Open Records Act?
I think that you could get through to a pending case that's still being prosecuted. Yes, I think it's intended to limit it to what I think customarily, at least, I've always understood as a city attorney was what you had to produce.
Okay. And then to the broader scope of what I think this bill is trying to do, I guess my question to the author is, normally in, for example, attorney-client privilege or work product privilege or psychiatrist-patient privilege, there are boundaries. There are things that you have to establish. It is limited in scope. It can be waived. It does not protect, for example, crime or fraud. And I'm wondering if you are contemplating in this privilege, is it really as broad as anything that is communicated to a legislator in the process of them doing their job as a legislator? Anything, any conversation, any record, any piece of data? Is that what we're really trying to do here?
First of all, my answer to that question upon reading what we have in front of us here is there is nothing that would prevent the waiving of the privilege or voluntarily participating in that sort of thing. But as far as whether it is intended to cover anything, again, I defer back to line 770 and 771 that is in the performance of a service or function of the legislative branch or on behalf of the legislative branch. So if it is in that performance and function, it would be covered under this, but those other provisions, the other exceptions and exclusions you spoke of, there's nothing I see in here that would prohibit that.
Thank you.
Representative Holcomb, do you have a question?
I do, Mr. Chairman. I want to ask about the carve-out on 55 and just if there's an explanation for those records, which are the access records to the buildings. I think there's some oversight aspect of whether or not somebody was actually working that day, and so if you can share just a little bit behind that? Is it a safety thing or something else?
Was that for me?
To whomever can answer it. Yeah, it's line 774 to 777, so
Yeah,
it's,
the exception 55.
yes.
Yeah, that's my understanding is without that exemption, all of the codes that are maintained by us could be subject to open records arguably. And it is a matter of not only of safety, but also of security in the building, because if you know all the codes, then you can make your own card and come in anytime. Now, you're talking to a guy who's more analog than I am digital, but that was my understanding of the need for that exception.
Okay, I could understand the codes, but it would seem whether or not we were using the access cards to actually access the building should still be subject to being disclosed?
Well, again, we're not talking about disclosure of facts. We're talking about production of documents here. So these are, electronic or tangible three-dimensional documents. So you could get electronic documents or electronic data relating to all that information, which would allow you basically to hack the whole security system.
Okay, all right,
At
thank
least
you.
that's my recollection as it was explained to an old guy.
Okay.
Leader Hughley?
Thank you, Mr. Chairman. To the chairman presenting the bill, just a point of clarification in line 767, it talks about the legislative branch, any members, officers, etc. And then when you go to the line 769 and later, it just says the legislative branch. So does that mean that anyone that's a member of the legislative branch this applies to, or does it apply to like an official committee or the House itself? Explain to me for clarification what we're saying now.
If I can try to answer the lady's question, again, this is the Open Records Act. So this is an act that provides generally that you have access to public records. There are a number of exceptions to that, and we're adding 3 exceptions. There is already, at least I understand, a legislative privilege that applies to communications and some written communications as well. But the Open Records Act does not apply to the legislature. It has not, since it was enacted. The Court of Appeals has said it doesn't apply to the legislature. But it would apply to the executive branch agencies. So this is just adding as another exemption communications they have with legislative branch or members, et cetera, thereof. So again, we're talking about a request for production of documents relating to these matters. These things would be exempt from disclosure under the Open Records Act. It doesn't necessarily mean you can't get it in litigation. That's a different matter.
So I am to understand then that where it says legislative branch in several of these places, that includes members as well as official committees and whatnot,
Yes.
whatnot.
But you couldn't make an Open Records Act request to the lady as a member of the legislature. It would be made to an executive branch or an executive agency, and this would be an exception to the things they would be required to produce in response to.
One other thing, Mr. Chairman, and this is not exactly a question, but I'm a little bit concerned that nobody knows where this came from and what is the urgency that brings us here on the 39th day at this hour.
And I suppose I don't know. I think it was just felt it would be good to put this in law while we had an opportunity to do so, to clarify and to further sort of clean up some issues that have arisen. The bill was initially because we had a court case that I think interpreted requests made to vendors who contract with local governments. And the understanding has always been you had to make the request to the local government, and then the local government has to track down the vendor and get the documents if they're responsive. The Court of Appeals read it differently. So we were trying initially in the bill to clean that up. Well, there have also been some Court of Appeals cases saying that the legislature is not subject to open records and open meetings, so we were cleaning that up, and then we were just adding these legislative privileges in here as well. So it was not viewed really as being a substantive change, but just as confirming what I think is already a reasonable extension of existing law.
Mr. Chairman, I'm not sure who this question will be direct to, but isn't it true that some years ago there was open records issues around back in the day when we had toll booths about the tags being able to be when people went in and out of that under open records, they were at one time subject to open records. And isn't it true the reason we took that away was because it was a security risk? People knew when people were in their home or not. And to that, isn't it true that 55, if this data were open, they would know if somebody was going to do something, ill-intended to a member of this legislature or a member of our staff, they would know the goings and the comings and when they were in and out of the building, and it's a safety issue because these are public records. A private company would never do that. Isn't that what we're trying to get here?
I mean, that's my understanding of 55 anyway. That's what that point is it's security.
Mr. Chairman,
and
if I
safety.
may, just as further clarification of what Chairman Leverett said, and I think to the point of what Chairman Martin was asking there, in some of the notes that the Speaker's office had provided me on this, exception 55 for security purposes such that no one could access data to track an individual's movements within a state building. So yes, it is exception 55 is primarily for security purposes for each of you.
Okay, have one last question, Representative Miller.
Thank you, Mr. Chairman. Thank you for the second bite at the apple. Something occurred to me. I guess I missed it when Chairman Leverett indicated that this is really more so designed to protect communications between the General Assembly and the executive branch. And I'm wondering, I know that this session there has been what I understand to be a whole lot of communication between the executive branch and the legislative branch about a certain priority. And I'm wondering if this is being done at this time in an attempt to shield the level of communication, pressure, exertion, all the other things that we've all talked about on the floor. Is that what this is designed to cover?
No, this has nothing to do with any legislative initiatives that have been launched this year. It's just, this was simply viewed as an opportunity to again, make some cleanup that was desired and was not viewed as being that great a substantive change. No grand conspiracy here.
Okay.
And to further that, it is my understanding that it is very rare that we have bills related to Section 50-18 in this code section. So as the chairman alluded to, most of these additions to the original bill were done to address issues that have come up over the last few years in communications and dealings through the courts on other issues, as well as concerns from the Prosecuting Attorney's Council and what we've seen out of the Court of Appeals.
Okay. We've heard the explanation and the questions on this. On Senate Bill 12 by substitute, is there a motion to do pass?
Motion do pass.
All right, have a motion and a second to do pass. Is there any opposition? Is objection? All those in favor say aye. Aye. All those opposed, no. It passes. Okay, thank you. Next, Senate Bill 20 by substitute, Chairman Martin.
Thanks, Chairman Parrish. Ladies and gentlemen, this Senate Bill 20 is in 5 parts. The first portion of the bill, parts 1 through 3, were originally passed by this body, this Rules Committee in this House earlier this year as House Bill 56. Those are as passed. That is parts 1 through 3 of the bill. Part 4 of the bill is the original Senate Bill 20, which passed out of House Higher Ed, and in Part 5 is just the implementation. So we have 2 pieces of legislation that have been vetted in the House Higher Ed Committee. One of those passed. What is in House Bill 56 what was in House Bill 56 to help everyone's memory was to extend to fallen public safety officers' spouses an opportunity for education. And part 3 of the bill is to make that same extension for public school teachers, public school professionals that are killed in the line of duty. And unfortunately, we had our first and I hope only 2 this fall. But that's what parts 2 and 3 of the bill, part 1 of the bill, allows checkoffs at the time you're getting your driver's license if you want to help fund these scholarships. That's what the bill does, Mr. Chairman.
Okay, any questions, Chairman Martin? Don't see any questions. Do I hear a motion that substitute to Senate Bill 20 do pass? So moved. Have a motion and a second. Is there any opposition? Okay, it passes. Okay, now let's set a third supplemental calendar for today. Senate Bill 12 by substitute LC 473721S.
Move.
Have a motion and a second. Is there opposition? Okay, all those in favor of putting it on, say aye. All those opposed, no. It's on. Senate Bill 20, Rule Substitute LC 610266S. Is there a motion?
Move.
Have a motion and a second. Any opposition? It's on. Senate Bill 36. Have a motion and a second. Any opposition? There's objection. All those in favor say aye. Those opposed, no. The ayes have it. Okay, hold on. He's going to pick that up and bring it back in just a minute, okay? Okay, while we're waiting on that, Senate Bill 46.
Move.
Have a motion and a second. Any opposition? It's on. And Senate Bill 255.
Move.
Moved and seconded. Any opposition? There is an objection. Okay. All those in favor of Senate Bill 255 going on, say aye. Any opposed? No. The ayes have it. Okay. Just sit tight for just a minute, okay? Okay, everyone have a copy of the proposed amendment AM 440228? Okay. Representative Evans, you want to explain your amendment, please?
Yes, thank you, Mr. Chairman. Ladies and gentlemen of the committee, this is a proposed amendment to Senate Bill 36. It simply adds to the end of line 67 of the bill. It already says benefits or exemptions, so it would just replace line 67 with the following. So it would say, nothing in this chapter shall be construed to allow discrimination in violation of a federal or state civil rights law or a local civil rights ordinance or resolution. The author of the bill has indicated both in Judiciary Committee and in the press that he does not intend Senate Bill 68 to be a tool for discrimination, so this just simply clarifies that is true. It is language that you will find in other state laws around the same subject matter. Also in conservative states such as Texas have language similar to this, and it just ensures that while we place value on religious freedom, we also want to make sure that no one in our state will be discriminated against, and this just allows that balancing that I think all of us would like to have do unto others as we would have those do unto us. And again, I'm not asking for this to be the rules to substitute this in. I'm asking for us to utilize the procedure that is provided for in House Rule 33.2 that says a modified structured rule bill, which this is, can have an amendment approved by the Rules Committee to have placed on the floor, and then whether myself or some other member attempts to move that is something that happens on the House floor. And I'm simply asking that this committee allow this amendment to be placed on the House desk for having the ability to be potentially moved in the House. That's all I'm asking.
Okay. You've heard the proposed amendment, and you've heard the motion that it be placed, that rules pass it out and place it on the floor. Is there a second to this motion? There is a second. Okay, all those in favor of moving this to the floor will say aye. Aye. All those opposed will say no. No. Okay. All those who want to send this forward, raise your hand. Help me count. 5, 6. Okay. All those opposed. Motion fails. Excuse me, Senate Bill 36 is part of the supplemental calendar. We had a motion do pass or be added to the calendar. Is any opposition? Objection? All those in favor of adding this to the calendar, say aye. Aye. All those opposed, no. It's added on. Okay, that's it. Thank you. Thank you for your patience.